Be ready. 5 seconds. Start. There is a clear-cut and well-demarcated sphere of activity in the field of crime detection and crime punishment. Investigation of an offense is the field exclusively reserved for the executive through the police department. The executive, which is charged with a duty to keep vigilance over law and order situation, is obliged to prevent crime, and if an offence is alleged to have been committed, it is its bounden duty to investigate into the offence and bring the offender to book. Once it investigates and finds an offence having been committed, it is its duty to collect evidence for the purpose of proving the offence. Once that is completed and the investigating officer submits report to the court requesting the court to take cognizance of the offence under section 190 of the code, its duty comes to an end. On a cognizance of the offence being taken by the court, the police function of investigation comes to an end subject to the provision contained in section 173(8) of the code. There commences the adjudicatory function of the judiciary to determine whether an offence has been committed, and if so, whether by the person or persons charged with the crime by the police in its report to the court, and to award adequate punishment according to law for the offence proved to the satisfaction of the court. There is thus a well-defined and well-demarcated function in the field of crime detection and its subsequent adjudication between the police and the magistrate. This view of the Judicial Committee clearly demarcates the functions of the executive and the judiciary in the field of detection of crime and its subsequent trial, and it would appear that the power of the police to investigate into a cognizable offence is ordinarily not to be interfered with by the judiciary. The principle therefore is well settled that it is for the investigating agency to submit a report to the magistrate after full and complete investigation. The investigating agency may submit a report finding the allegations substantiated. It is also open to the investigating agency to submit a report finding no material to support the allegations made in the first information report. It is open to the magistrate concerned to accept the report or to order further enquiry. But what is clear is that the magistrate cannot direct the investigating agency to submit a report that is in accord with his views. Even in a case where a report is submitted by the investigating agency finding that no case is made out for prosecution, it is open to the magistrate to disagree with the report and to take cognizance, but what he cannot do is to direct the investigating agency to submit a report to the effect that the allegations have been supported by the material collected during the course of investigation, and the police has statutory right to investigate into the circumstances of any alleged cognizable offence without authority from a magistrate, and that power of the police to investigate cannot be interfered with. This court, while explaining the nature and purport of the inherent jurisdiction of the High Court, observed that in exercising jurisdiction under section 561A of the Criminal Procedure Code 1898, the High Court can quash proceedings if there is no legal evidence or if there is any impediment to the institution or continuance of proceedings, but the High Court does not ordinarily enquire as to whether the evidence is reliable or not, where again investigation into the circumstances of an alleged cognizable offence is carried on under the provisions of the Criminal Procedure Code. The High Court does not interfere with such investigation because it would then be the impeding investigation and jurisdiction of statutory authorities to exercise power in accordance with the provisions of the Code of Criminal Procedure.